Thanks very much. I'm going to pick up on a few themes that were in the previous presentation, because there is a sort of a cornucopia of issues around data protection and freedom of information, as well as some of the issues around protecting your data and your IP rights. So I think some of the themes that I saw before you'll hear again, and some of those will come back to sort of obligations, lawfulness, fairness, and going forward in that. So just as a quick overview of what I'll cover, I'll look at the data legislation and I'll go into a little bit more detail. I'll look at some court decisions and some other guidance from data protection authorities around that, some of the more recent developments that are happening. And one thing I can tell you is my life as a data information lawyer is that we thought things were hectic in 2017, but they're still hectic today. So it's such an evolving area that it's difficult to keep up, even for us that just do this all day, every day. I'll then hit on some free flow around non-personal data, touch very lightly on data ethics, and then again, a lot of things around how you can sort of protect your intellectual property and then contractual obligations looking at data. So to kick off, general data protection, you've just heard about it. I think I'll just go into a little bit more detail on some of the issues around that. There's been data protection law for personal data. Now in the UK, we define personal data, as you saw a minute ago, it identifies or is identifiable relating to a natural living person. In some European countries, it covers people who have died recently, but in the UK, it's only a living individual. So there are derogations between different states depending on if you're doing some cross-border research. So that's one thing to keep in mind. Now, we have 7 key principles. And like I said, these key principles, you may hear them coming and going on a number of themes again, but I just want to sort of go into them because I think they're the fundamentals to keep in mind. Now, you have to have, when you're processing personal data, the first thing is it has to be lawful, it has to be fair, and it has to be transparent. Those go together and they always get kind of thought about together as one group. The next thing you have to do is think about your purpose limitation. And this goes back to the thing about when you were giving consent, what are you really giving consent for? You need to have a defined purpose of what you're using the data for, because if you're going to use it for another purpose, it needs to be checked that that's actually okay. Otherwise, you're breaching the law. Third one, data minimization. Now that was picked up again a minute ago, and I'll come back to this because it will be a theme that runs through this data minimization. I think one thing to say about data minimization is that we also have a concept in personal data protection called privacy or data protection by design and by default. So you should think about the data that you want to get the outputs or the research that you're doing. Now, I know that certain big data researchers, they want lots of data to kind of then see what happens. And so there's going to be an inherent kind of conflict between the two of those. The next main principle is accuracy. You should be using data that gives you an accurate output or an accurate input. So you want to make sure, again, it's fit for purpose. Storage limitation, or what we call, the retention of data. Don't keep it longer than you need it. And if you don't need it in personally identifiable format, i.e. anonymized data, then anonymize it sooner than later, and then you can keep it for longer. The other one is integrity and confidentiality, but we also just tend to call it sort of by its sort of face one is keep data secure. That means within an organization and beyond the organization. You don't want a data breach, you don't want data being leaked to the public, but you also want to keep it secure within an organization. Only those people who need to see the data should be looking at the data. And then finally, and this is the kicker, accountability. Now, I've heard a few mentions ago about a lot of forms and a lot of documents. Well, sadly, we live in an age where as the rules for using data become more and more prevalent and become a little bit more stricter, you have to be able to demonstrate that you've met your obligations under the law. So those are the main principles, and those are if you keep those in mind as your framework, then you're probably always going to be doing all right, because those are the things you'll always come back to. Then we want to look at sort of what the legal basis are. So that first one is it's got to be lawful, fair, and transparent. So you have 6 bases, what we call, or 6 grounds that you can process personal data for. One of them is consent, and consent was mentioned earlier. And I'll just touch on consent for a moment, because I think it's probably consent will be one of the ones you rely on the most, particularly if you're looking at other ethical issues or issues where you're actually going directly to data subjects or individuals to get their data. Now, I saw the examples of consent before, and I thought that was a really good example. And there's just a couple of things to remember about when you're using consent for the purposes of the legislation, which goes possibly different for the purposes of other your research obligations. But you have to use clear language to tell them exactly what you're doing. So if you want to use it for more than one project, you need to say, we want to use your data for this project and this project that will follow on from it, or at least for this purpose. We want to use your data for 3 cancer studies, and they will be done by these people. And you have to tell them who you are and what you're intending to do. You also have to tell them that they have a right to object, or to withdraw their consent at any point in time, which means that you have to have, there's that word again, documentation, to make sure that if somebody does come along and says, well, hey, actually, I don't want my data to be used anymore in your study, then they have a right to do that. And that has to be as easy as them giving their consent in the first place. So that's the one. The other ones that you'll probably come across really would be what we call legitimate interest, which means that you do a balancing exercise between your legitimate interest to be able to do research and the individual's right to privacy. And that comes into issues around pseudonymization and other aspects of where you'll get the data from. You might have one as a public task, depending on or how you're doing the research, whether it's sort of government mandated research or one of those. Then we have the sensitive data, which again was mentioned a short while ago. Now, this is data that deals with issues around race, political opinions, health data, genetic data, biometric data when it's used to identify an individual, political views, sex life, that sort of thing. So it's things that are quite intrusive in people's lives, and so therefore it has an extra level of protection. Now, I mentioned consent a minute ago, but if you have what we call special category data or this sensitive data, you need explicit consent. Not just, I want to use your data for some research. I want to use your health data for some research. I want to use information about your ethnicity for this research. You have to be much more clear about what data you're using rather than just, we want to use your data. But what you also get, which is a little bit of a get out of jail card free to a certain extent, is that there's a recognition in the data protection legislation world that research is important. So while you can use the explicit consent to use this sort of sensitive data, you also have you can use it for the purposes of research, and we call it the sort of research exemption. And what it says is that you can process the sensitive data as long as you have certain appropriate safeguards. So these appropriate safeguards are going to be around, in effect, data minimization. You should only be processing the data that you need. You have a safeguard pseudonymization. So as I said that, you're going to try to minimize it. So basically, you can do this without really making any distinctions about one person. You're kind of looking at it in that aggregate way. You're not infringing on people's privacy. If you can do the research with the data in anonymized data, then you should be doing the research with anonymized data. Now, the good news is, for research purposes, the research is sort of broadly defined. So it covers anything around technology, development, fundamental research, applied research, and even privately funded research. Then you also get, coming on to our Data Protection Act in the UK, is what we call some derogations. So one of the things you have when processing personal data is that data subjects, people have rights. And one of those rights is transparency, wanting to know what people are doing with their data. They also have rights around, I want access to the data that you hold about me. I want to object to the data, the processing that you're doing. I want you to delete my data. I want to take my data somewhere else. There's a number of rights that we all have, irrespective of who's processing our data. Now, the good news is there are derogations. With that derogation, for you to be able to use the sensitive data, you also have certain things that you don't have to do if someone asks. Excuse me. And as long as you're doing it in the guise of the research and you've met your other obligations, if someone says, I want all the data that you hold about me, you don't have to do that. You're kind of exempt from that. You don't have to rectify data if there's a problem with it. And you don't have to give them their data back to go and take it somewhere else. Now, weirdly, there's a sort of a typo, I have to say, in the GDPR, because in the rules about erasing data, or what we say, the right to be forgotten, where I want to say to someone, you no longer need my data, I want you to delete it. Research is mentioned under that right, but under the research exemptions, that's not mentioned. So there's a disconnect between the two. But in effect, we think that you would also be exempt if somebody said that they didn't actually want to, you didn't have to delete someone's data. So then looking specifically in the ICO one again, like I said, the main point that you have is that as long as doing these things of giving someone their data or restricting the data, these derogations I've spoke to, insofar as that would impair your research, then you're exempt from doing that. But there's another catch. You also can't put out the results of your research or statistics from the results that is in a format that enables a living person to be identified. Now, this, I think, goes to the question a minute ago about the linked data sets, and it also comes back to the Netflix example earlier. So this is about when putting out the research results, you need to do it in a sufficiently aggregated or way that you couldn't go back and actually try to find out who someone is. That could be a trick. And I think as we look at big data going forward and looking at those data points, that may become more difficult for researchers to do. I'm just going to jump onto the Freedom of Information Act again, and I know that was spoken about previously, but I just want to highlight that there's actually, I think the Queen Mary case was a really good example, and I have to confess I used to work at the ICO, so I've dealt with a number of these issues back in the day when I was working for the regulator. And you'll also be pleased to know that in addition to the future publication exemption, that you researchers, again, you get your own special exemption, which is that if you are, we call it the research exemption, basically, section 22A, that's one to note for yourselves. Basically, if you are intending to publish, so any information that you obtain or is derived, so you don't have to actually get it, but derived information from a program of research is actually exempt if the program is continuing with the view to publication. Now, that could be publication by you, that could be publication by someone else. As long as there's going to be some publication in the future and there's a prejudice to someone of releasing that data too soon, whether that's the prejudice to the program itself, it's a prejudice to the interest of anybody actually within that program, or it's a prejudice to you as an authority or someone else who's involved in that program, or another researcher, someone else who's holding that information. You don't have to publish it, but you do have to do a public interest balancing test, basically saying there's a public interest in us being able to do this in research and then put it out when it's ready to go out. You can have your controlled data release program for other people, but you're not putting it out to the world at large. You also get an extra little get out of jail free card, as we call it, which is if someone makes a request for your information under Freedom of Information, even telling them that you have that information would be prejudicial to the research that you're doing, going back to that list, either to yourself, to the program itself, or to one of the bodies dealing with it. You actually don't even have to tell them that you hold it. So you can just say, we can't confirm or deny that we even hold this information. So you're not giving anything away. And there's been a very recent case during COVID times that's a follow on from the Queen Mary case, which actually did say in that case, they did have to release the information. There's a recent King's College case, funny enough, about the same piece of research. Whatever this PACE research was around the cognitive fatigue, whatever it is a very hot topic because it's had probably about 7 or 8 FOI requests about it. But there's another ICO decision notice where they allowed the exemption to be put into play, and King's College, who also held some of the information relating to that study, did not have to release the information. So just coming back to the next one. So just looking at a few other bits of guidance that we have around shifting back to the sort of data protection world. I'll go on around sort of accountability and governance. So I said accountability is a very important aspect now. It is actually a principle that you have to do. So we have the Information Commissioner's Office, which is the UK's data protection authority. So they're the ones who'd have to answer to on some of these AI data protection issues. They've put out some guidance. They actually have what they call an AI accountability framework, which is very long, and it talks about all of the issues related to AI or use of algorithms in personal data. So they recognize there's a lot of benefits to that, but they also recognize that it raises significant risk to the rights and freedoms of people, and also these compliance challenges for organizations who want to use this, including researchers. So basically what it says is that you should embed your data protection by design and by default, which I mentioned earlier, into your culture and your processes. Now, these can be technical issues, but these should also be sort of policies and operational issues as well. And that's going to be difficult with AI systems, but you're going to have to, you in effect have to do this. And it has to be done at a senior level. So it has to be bought in by the entire organization, and it shouldn't just be left to researchers or the data scientists or the engineers. It has to be a team effort, and that goes a long way, because it has to come in from the legal, the compliance, what's trying to be done for the research, ethical, everything else. You should be taking a risk-based approach. So if you have low-level data that's not very risky to an individual, then that your sort of accountability obligations are a bit less. If you're looking at high-risk data, such as health data, the sensitive data we talked about, again, that would be potentially a little bit higher, and you would then, what we'd like to do a data protection impact assessment. And that's one, particularly if you're doing large-scale processing of what we call the sensitive or special category data, and you have to basically set out what you're trying to do, the purpose of it, what the risks are to these people, and then the steps you're going to take to mitigate those risks. You might need to do some other ones around some other processing. Now, the other one that you'll have, just looking at the AI and looking at the ICA's guidance, is in data protection terms, we have what are called controllers and processors. In a nutshell, a controller is the person who decides what data will be processed and why. The processor is the one who just deals with the data on their behalf and basically does what they say. In an AI algorithm relationship, it's a bit more complicated. And that's something that will have to be developed in time, but it's something that you'll have to think about as you're entering into relationships with people to undertake some of the processing for you. And then just going on to the French, basically the French health data one, I'm going to jump to the Schrems decisions, which briefly, because you may not know that one, but basically if you're sending data abroad, whether it's going to with Brexit coming, it could be to the European Union, or it could be to another third country, there are certain restrictions. And there was a recent court decision in the European Court that said that certain safeguards that were in place probably weren't actually adequate for the protection. And you have to look at a lot of other mechanisms to do that. So if you're looking to go using a processor abroad or a cloud provider abroad, these are things that you need to talk to your legal department about to make sure that whatever contracts you have in place are fit for purpose. And they have new guidelines that have literally just come out last week that we're all, as lawyers, trying to get our heads around and see what this means in practice for people who actually need to send data abroad. So basically, I just wanted to touch on that to demonstrate how serious that decision was. The French Data Protection Authority, the equivalent of the ICO, the CNIL, they told the French Health Data Hub to stop using Microsoft as one of the cloud provider and service users for this COVID health hub for research purposes, because they said that it didn't comply with what the court said in the Schrems decision. Now that went up to the France courts, and they basically said, nope, we disagree with what the regulator says. This is very important. Things need to be put into place, and we're not going to stop the flow of data. So again, you're going to have an inherent conflict as we're all adjusting to what the new rules are, that there may be decisions by regulators that get overturned by the courts, or the courts may be taking a more protective approach to people's rights. And just two more little points on that. We have what we call None of Your Business, which is a charity that sort of kicked off the whole Schrems things. Schrems decision is by a guy named Maximilian Schrems, and he is the one who made the complaint, who has now brought down 2 internationally agreed treaties relating to the transfer of personal data. And none of your business is his charity. They're very active in making sure that people's personal data is protected and processed appropriately. And they've made over 100 complaints across Europe about businesses and other organizations processing personal data. This is a good reason to make sure that your documentation is appropriate. If you're looking to see what's happening in the world of enforcement and whether it may affect you, they also have a GDPR tracker website, which you can look at to see what's happening there. Then briefly, I'll go on to the free flow of non-personal data. Now, the good news is if you're dealing with non-personal data, you can just put the GDPR to one side and you really don't have to think about it too much. If you can genuinely anonymize your data, then again, you're outside the realms of the GDPR. Just a couple of things. So when we're looking at industrial data, anonymized personal data, certain statistical data, that will all be non-personal data, and you don't have to worry about all of that legislation I've said, except for the freedom of information may still come and get you if you are a public body or university. The European Commission is very hot on research and developing data and for the economy as well. So one of the things they're looking at is making sure that data flows, and we're talking about non-personal data, flows freely across the European Union. So they have a lot of policies and initiatives in place to ensure that there's free movement of that data, that we have good self-regulation using cloud security, basically switching cloud providers. So if you're a university or you're a researcher, you're using one and there's something that's better, and getting the European cloud for research bases set up. So they're very hot on that. So again, in the research area, you're on friendly territory and they are doing what they can to help you. But at the same time, we then have mixed data. So mixed data is in effect, I've got some non-personal data, I've got some personal data, it's all mixed together. What do I do? Can I treat it differently? Can I really slice and dice my data? Possibly not. The general rule is if this data is inextricably linked, then you in effect have to apply the GDPR to the whole data set. If you can separate it out, that's great. You can process your non-personal data without worrying about the GDPR and those other obligations. If not, you have to basically treat the whole thing as though it's personal data. And that may be at times, it may be technically or economically inefficient or impossible to, in effect, remove the data to separate the 2 different types of data. And then you're back into where we were a minute ago. So then the next thing we have is the new data strategies, and data strategy is the hot topic at the moment. So the European Union has a data strategy, and also the United Kingdom has its own national data strategy. If you're dealing with other European countries, they'll probably each have their own data strategy as well. Another good use in there is that researchers are on the radar. So the data strategy is basically for both the European Union and the UK. It's in effect, they're trying to make the EU, the UK more competitive globally and a leader in a data-driven society. So again, within the EU, they're looking at a single market where the data can just flow easily for the benefit, including for researchers. They're trying to set up clear rules for access to data and reuse of data, looking at investing in infrastructures for storing and processing the data, looking at issues around the European cloud capacity, again, European data in key sectors, interoperable data spaces. Again, this is one for researchers as well. And then also giving people, you, me, everybody, again, ways that we can stay in control of our data, so that if I wanted to let my data just be used for research, I could in effect just kind of put it out there and say, researchers, help yourself to my data, and that sort of frees up you and you can know where data sets are to go and retrieve them. So I just think that those are one of the things that are happening. It's all still in the sort of early stages. 2021, COVID depending, because a lot of this was starting to happen this year, and then with COVID, everything's been pushed back a little bit because obviously for other reasons. But at the same time, the good news is that it's kind of highlighted the need for better access to data and for research purposes. It's kind of gone back and forth a little bit. So again, so at the European level, even though with Brexit, I think it's still good to know this, they're trying to have an enabling framework for the governance of what we call common European data spaces. And this would be, again, to help facilitate decisions on what data can be used, how it can be used, and by whom it can be used for scientific research purposes that would in effect be compliant with the GDPR. So it's sort of mechanisms to assist you with meeting your GDPR obligations. They also have another one where looking at, again, the cloud infrastructure, where there's the public good where you can merge secure data processing and storage, again, that would help for research institutions. Then we have the Common European Health Data Space for the diseases, which again, I think COVID has really pushed that one along. And then the European Open Science Cloud that you'll have in that respect. Moving swiftly to the UK National Data Strategy, it's very similar to the European one. The main driver here is to find ways that data can be used responsibly, lawfully, securely, fairly, ethically, sustainably, and accountable for supporting innovation and research. They're not planning any new legislation, but they are looking at ways that non-legislative measures can assist. And then you're looking at things like NHSX, which is their data strategy for health and social care, and opening up the data sets again for that. Data ethics, I'm only going to touch on for 2 seconds because I know that that's the big thing that you guys are looking at, and you probably already have a head start on ethical uses of data. But just to say, it's kind of creeping into the compliance area. So the European Data Protection Supervisor, again at a European level, has a 5-year program looking at data ethics and sort of how that works with data compliance, because as part of getting your compliance for personal use of data, ethics may come into that for the fairness element of it. The Information Commissioner's Office in the UK, the ICO, they have now appointed a data ethics, I think he's an advisor or policy advisor around that. So again, they're now looking at that along with Alan Turing Institute at what data ethics means for the use of personal data in the UK, and how that can again fit with meeting your GDPR compliance or your data protection compliance. And then the other one, just briefly, we've got Data and Society, which is a US-based one that's done a lot of research around big data and technical research, and highlighting, again, some of the ethical issues brought around by that. So I'm going to just stop with data for the moment and then move on to intellectual property very quickly. First of all, I'm not an intellectual property lawyer, but I work very closely with them because of the data issues. And then basically, these are some top tips, really, to negotiate when you're starting off on a research project, and things to think about really before you get into it. Again, we're talking documents, paperwork, and that, but these are some of the important things to think about. The first one is, if you're collaborating with your research, who's going to own, who's going to manage, who's going to exploit any IP that they get that you already own or that might be created. You need to think about your contracts in advance of the project, because you want to put in place some of these issues I'm talking about now. Think about them before you start signing contracts, where you will be signing contracts either with funders or with collaborators. So the key points is, what is the scope of the project? This comes in, I think, as well as under the GDPR when we're talking about the purpose. You need to know what your scope of your project is. You need to know what the potential IP rights are going to come out of it. Ownership. Who's going to own? You don't really own data, and I'll come on to that in 2 seconds, but basically, it may not be one party's desire to keep all the IP. You might want to look at licensing. You might be looking at royalties, because once you've got IP, you might have to then maintain it and enforce it. And that may not be where you want to go if you're a small researcher and something's coming out of that. But if you do have more than 2 people, you need to know where the chain of responsibility is and who's responsible for what aspects of it. Think about what your background IP is, if you're using any background IP, to the extent that this is needed for the research that you're doing, and make sure that that's licensed appropriately for the other parties to use. Confidentiality, very much think about that. That goes to the both data protection, keeping the data secure, your controlled data release program, your freedom of information, and potentially other issues around IP, because you don't want to disclose it because that could affect a grant of a patent, or also creation of a design right. Infringement and enforcement, just very briefly on that one, again, going back to the who's owning the data or who's owning the IP, who's going to be responsible for sort of dealing with infringement of it or enforcing it. Do you need all the consent of everyone? Will someone be in charge of that? You need to look at that because litigation can be expensive. Do you really want to go down the litigation route? And those other aspects to think about, and who would be funding that. Exiting, very briefly, all projects come to an end. What you don't want is at the end of a project to have all these awkward conversations that you should be thinking about at the beginning of the project. And then just briefly to say, non-personal data, personal data, nobody owns it. You have rights over it. You can exercise obligations, or you have obligations over it. People have rights over their data, but there is no ownership. So we're looking at contracts, we're looking at GDPR, we're looking at FOI, we're looking at IP rights. And that's why I said it's a bit of a cornucopia to see, in effect, how you would be looking at the data that or information that you'll be using. And those are things to think about at the beginning of a project rather than the end of a project.